you. Welcome to the City of Miami Commission.
You want to start this hearing?
No, hold on, Todd. I know what I'm going to say.
Okay.
October 24th, 2024, we are now going to start our Southeast Overtown Park West CRA meeting. I'm going to turn the mic over to our Executive Director, Mr. James D. McQueen. Dwight?
Thank you, Commissioner. We have a few items, and Attorney Brown will read those items into the record if it's your desire.
Good afternoon. The first item for consideration is a resolution with attachments authorizing the Executive Director to execute a housing subsidy agreement attached and incorporated herein as Exhibit A, further authorize disbursement of funds in 5 annual installments of $1.6 million, not to exceed $8 million. The second item is a resolution by 4/5 vote ratifying, approving, confirming the Executive Director's recommendation, finding that competitive negotiation methods and procedures are not practical and advantageous, waiving the requirements of competitive sealed bidding, and further approving a grant request in the amount not to exceed $2 million to support Harlem Square LLC to underwrite the costs associated with the development of Harlem Square Supper Club, a full-service supper club located at 173 Northwest 11th Avenue in the city of Miami, 11th Street, I'm sorry. The third item is a resolution by 4/5 vote ratifying, approving, confirming Executive Director's recommendation, finding that competitive negotiation methods and procedures are not practical, advantageous, waiving the requirements of competitive sealed bidding, and further approving a grant request in the amount of $180,000 to support the Overtown Optimist Club to provide youth programming for youth residents within the development area. Item number 4 is a resolution by 4/5 vote ratifying, approving, confirming the Executive Director's recommendation, finding that competitive negotiation methods and procedures are not practical, advantageous, waiving the requirements of competitive sealed bidding, and further approving a grant request in the amount not to exceed $167,500 to support the following organizations for arts and culture programming within the redevelopment area: the Black Archives History and Research Foundation of South Florida, Gateway Airport Concessions, Miami-Dade North Arts Humanities Foundation, also known as Miami MOCAD, Norwood Consulting, and Urgent Inc. Item number 5 is a resolution authorizing the Executive Director to execute a lease agreement substantially in the form attached as Exhibit A for approximately 1,000 square feet of commercial space at 249 Northwest 6th Street, Suite 108, Miami, Florida, for a 10-year initial term at a total base rent of $20,000 per year with a 5% cap on annual increases after the first term. Item number 6. This item is as amended. I'm going to read the amended title into the record. A resolution of the Board of Commissioners of the Southeast Overtown Park West Community Development Agency with attachments authorizing the Executive Director with prospective authority to negotiate and execute a sublease in substantially the same form attached as Exhibit A for 1,000 square feet of commercial space for retail use at 249 Northwest 6th Street, Suite 108, Miami, Florida, 33136, in all forms acceptable to the General Counsel, subject to the expiration of a 30-day notice of disposition of the property and a request for proposal attached and incorporated Exhibit B at least 30 days after the Southeast Overtown Park was notifies this Board of Commissioners the recommendation to accept the winning proposal pursuant to Florida Statute 163.380(3A), providing for incorporation site, providing for an effective date. As amended, item number 7 is a resolution providing for the issuance of tax increment bonds in the amount not to exceed $150,000 to be used for construction. I'm sorry, $150 million. Those zeros got me kind of confused. McQueen was saying 150,000? Yeah, 150 million to be used for construction, rehabilitation of affordable housing, financing, and construction of capital improvements within the redevelopment area, and refinancing certain outstanding obligations. others as another item.
Settlement agreement.
There's one more item. Item number 8 is a resolution of the Board of Southeast Overtown Park West Community Development Agency with attachments authorizes the Executive Director to execute a settlement agreement attached and incorporated here in Exhibit A between the Southeast Overtown Park West CRA and HA Contracting Corporation in the amount of $2,147,296.54, allocating the funds from the grants and other aids account. Further authorize the Executive Director to negotiate and execute any and all documents necessary, including any and all amendments thereto, all in forms accepted to the General Counsel, providing for incorporation sign, providing for an effective date.
Thank you. At this time, I will open the floor for public comment. If there's anyone here that would like to speak on any of the items that were identified today for this meeting, please step forward. Seeing none, public comment period is now closed. If I may have a motion to approve the meeting minutes for September 7th, 2024 and September 26th, 2024. I have a motion.
Second.
I have a second. All in favor?
Aye.
Motion carries unanimously. Gentlemen, are there any items before us that you would like to pull for discussion? Seeing none, I have RE 2, 3, and 4 are 4/5 items, just to make it clear. May I have a motion to pass RE 1, 2, 3, 4, 5, 6, 7, and 8?
So moved.
I have a motion. I have a second. All in favor?
Aye.
Motion carries unanimously. Thank
With
you
RE6
all.
amended.
With RE6 as amended. Thank you all. Thank you all for attending. This concludes the Southeast Overtown Park West CRA meeting for October 24th, 2024. Once the clerk flips the tape, we will resume the commission meeting. Thank you, sir. No, I'm stuck.
Chair, we're good to go.
Thank you, Mr. City Clerk. At this time, we will resume the City of Miami Commission meeting for October 24th, 2024. Give me 1 second. I was in the middle of. Okay, here we go. Gentlemen, may I have a motion to approve meeting minutes for our first budget hearing, September 7th, 2024, our City Commission meeting for September 12th, 2024, and September 26th, 2024, and the second budget hearing of September 26th, 2024. I have a motion. I have a second. All in favor?
Aye.
Motion carries unanimously. For the consent agenda items, are there any items that you would like to pull for discussion? Commissioner Reyes? Commissioner Cabela?
No, I'm good.
Okay, then. May I have a motion to approve CA 1, 2, 3, 4, 5, 6, and 7? And
Motion.
I have a motion.
Second.
I have a second. All in favor?
Aye.
Aye.
Motion carries unanimously. our PH items. I want to make sure that PH1, I'm shown as the sponsor, Todd.
Yes, that was stated. We'll show you as a sponsor for PH1. That was for RE5 and RE12 from this morning. For PH1, we'll show you as a sponsor.
Okay. Gentlemen, from the PH items, are there any items that you want to pull for discussion?
No.
It's only two. No?
No, I'm good.
Okay. May I have a motion for PH1 and PH2?
So moved.
Motion, second.
I have a motion and a second. All in favor?
Aye.
Motion carries unanimously. I'd like to say congratulations to the Center for Haitian Studies. Thank you, our former commissioner, Commissioner Monestein. Please.
Thank you for the privilege, Madam Chair. Good afternoon, Commissioners, Mr. Manager, and Mr. City Attorney and Clerk. Thank you for this opportunity. Dr. Pierre had to leave because of another meeting, and Mr. Klein and I, we volunteer at the clinic, and we thank you for approving this item on behalf of the center, and they'll be continuing to provide services to our community in Little River and Little Haiti, as you know. Thank you so much.
Thank you. It is an honor for me to sponsor this item. The center resides in District 5. They do fantastic work. They provide health care services free to the community of our uninsured community. They've had an annual health fair for the past 33 years, and this year they surpassed the number of residents and children, families that they provide services for. I was so impressed with what was going on there, and ran into a friend of mine that I haven't seen in years. It was a wonderful, wonderful occasion, and I can't wait to continue to do good work with you. So thank you. And thank you to my colleagues for seeing that this was a worthy initiative. Thank you. Thank you for coming. We are on to our resolution items. We have 3 mitigation items. So let's start with our mitigation, RE1.
Good afternoon, Madam Chairwoman, Commissioners. Robert Santos, Harbor Eco Compliance Director. RE1 is a mitigation of a property located at 2749 Southwest 5th Street. Respondent is Mancini Holdings 12 LLC. The case in question is CE 2016-010484. Notice of violation was issued on June 7, 2016 for construction work without permits, operating without a certificate of use, operating without a business tax receipt, operating without a solid waste hauler, and failure to have a designated handicap parking space. The case was adjudicated on July 18, 2017. It complied on October 31st, 2019, running for 876 days and accruing a total of $219,000. The respondent is offering 8%, which is $17,500. I'm going to put in the record before I yield to Legal Division Chief Dooley that there were plenty of exchanges and emails. The respondent thought this case was to be mitigated. They didn't apply. They didn't put the address on the process. There was 2 separate contiguous addresses, but this case was never included. So it kind of fell through, and they have to go through this process. I want to put that in the record.
Good afternoon, Rachel Early on behalf of the Office of the City Attorney. Just before Council speaks, just to clarify, the property did have 2 other violations. They cleared all of these up before the pandemic. During the pandemic, we were emailing back and forth using CityView, figuring out what the violations were. And I know there's even an email from me that says, okay, this is it. Well, guess what happened? It wasn't it. There was something else. So this would have been taken care of over 4 years ago. But suffice it to say, sometimes in the CityView system, things don't line up the way they're supposed to. And I missed it, but it is what it is, but they are making that offer. I just wanted to let you know that this owner had come forth a while ago, and I was very surprised and started researching my own emails because I had remembered it.
Thank you.
Good afternoon.
Good afternoon. Maria Larbier on behalf of the respondent. It's exactly what happened. There were 2 buildings. They're adjacent to each other. Each of them had 2 violations. There were communications back and forth based on the subject line. We thought that, or our client thought that they had been corrected in full, and then 3 years later, we found out that there weren't. They've diligently been working to correct them. They did settle the first 2 violations for about $10,000 back then. We're offering $17,500. The only thing we would ask is if there could be a payment plan, 24 months, but that's the offer due to the circumstances of the case.
Commissioner Cabela, I believe this is in your district.
No, I think it's either in Carollo or Reyes.
It's Commissioner Reyes's.
It says District 1. Oh, I'm sorry, I'm looking at the wrong.
Yes, sir. it is.
I'm looking at the wrong.
I'm sorry. You know,
It's
I'm
District
still a little confused about the different changes that have been done. Okay, what's the percentage that you are offering?
I believe it's
8%, sir.
8%, and this is for how long this has been?
I'm sorry.
For how long there has been this violation going on?
This violation complied back in 2019. The property owners came to us in 2020 or 2021 in the pandemic when we were still doing online settlements, trying to get cases moving. We missed this violation at the time. We took care of the other 2. So it's been complied for over, almost 5 years. Almost 5 years
That
now.
has been complied?
Yeah, they've been complied for almost 5 years.
Okay,
They
fine,
complied
fine.
within about a year and a half or so. So they're offering the $17,500.
Okay, I move it.
Second, all in favor?
Aye.
and 24
For the
months.
24 months,
Is that
yes,
Okay,
as amended.
Just so you know, we don't have payment plans.
No.
But we can put in the order that they will have 24 months to pay it. That can run with interest unless you want to say otherwise. It's up to you.
that's fine. Fine with me.
No,
As long as they pay.
as long as they pay that full amount.
That's right.
Okay, I'll amend accordingly.
I have a motion and a second. All in favor?
Aye.
Aye. Motion carries unanimously as amended. Thank you.
Thank you.
RE2 has been
Been
deferred. RE3,
RE3 is a mitigation of a property located at 740 Northeast 86th Street. Respondent is Claude Villette. There are 3 separate cases within this property. The first NOV CE 2020-07576 was issued for failure to maintain exterior, vacant and blighted property, outside storage, construction work without permits, and failure to register a vacant structure. NOV issued on April 14, 2020, adjudicated on September 8, 2021. This violation ran for 981 days, accruing a total of $490,500. Case 2 ran separately, CE 2018-020929 for failure to register a vacant structure. NOV issued on October 11, 2018, adjudicated on September 9, 2019. That violation ran for 1,694 days, accruing, and I have here, $423,500. A third violation separately for graffiti, and I'm not going to go into the details because we do have legislation that graffiti alone should not be adjudicated, but that accrued a total of $248,750. If we add all the 3 violations, they accrued a total of $914,000. If we remove the one with the graffiti, the amount, bear with me a second, I have it here, is for 90, is $914,000. Of importance.
I thought you said all 3 are 900.
All 3 are $1,160,750. Apologies. I did.
Okay,
I
1
did say
million.
$1,162,750. That's for all 3.
Okay,
If I back out the graffiti adjudication, the total amount for the first 2 cases is $914,000. I understand that counsel for respondent is going to talk about the fact that it went to unsafe structures and they thought that once it went there, it was the responsibility of the city to demolish. I'm going to yield to legal, but I am going to tell you no such thing exists. The collective offer from the respondent is $27,270, which is 3% of the accrued amount of the first two. I also need to put into the record the fact that this property is not homesteaded. It had 31 cases in the period since 2005, 25 of which were cold cases. This was a blight to the area and significantly and adversely impacted the neighborhood.
Attorney Dooley?
That's fine. I would yield to counsel and
Oh,
then...
Director said that you said something about we would get clarification from Attorney Dooley about the demo or something?
Oh, no, the city demolished the structure. I don't know. We'll wait. I'll let counsel go. I'll let him do it.
Good afternoon. How are you?
Good afternoon. Jason Martorella on behalf of Claude Villette and Anthony Murray, the owners of the property here on 86th Street. We are seeking a mitigation, a significant mitigation, but there are reasons for the leap that we're asking the fines to be reduced to, and it's reasonable under the circumstances. And those circumstances are, first, we're dealing with a situation in which the code violations appear to be somewhat overlapping. There are, for example, two different code violations dealing with registration of the structure. We're also dealing with fines that are exceed the value of the property by almost double. It's almost triple the value of the property. Second, we're talking about here individuals. They're not, in very deep pockets. There's not money available to pay all of these fines. Third, we're dealing with, at the time of the code violations, the owner of the property, who's still one of the owners of the property, was a citizen of France. He was residing in Martinique. He did not know about any of these violations until this year. Now, I've been assured that notice was posted on the property in compliance with the law. We don't have any reason to dispute that, but the fact of the matter is that my client, who was the owner at the time of these violations, did not know about them until this year. Third, we're dealing with a case where there was a demolition order that was entered. And going back to the issue of there being overlapping violations here, all of these violations stem from the condition and the registration of the structure that was on the property. Now, there was a demolition. Oh, sorry. Oh, okay. There was a demolition order that was entered in 2019, and if according to that demolition order, the owners had 30 days to demolish the structure, and if they didn't demolish the structure, the city would be demolishing the structure. So if the city would have demolished the structure at that point in time, we wouldn't have had code case number 1, which accrued total fines of $460,000, or sorry, $490,500, and the fines on the other two cases wouldn't have been as severe. It's just, I understand the point that the city doesn't have a duty that could maybe subject the city to liability to like third parties if somebody had come onto the property or the structure and got injured and tried to sue, one of the owners. But here we're not looking at, mitigating or compensating for liability incurred to a third party. We're talking about, the fines imposed by the city itself. So they entered this demolition order, which required demolition of the property in 30 days, and instead of demolishing it, they didn't demolish it for years, and that's the reason why these fines, in large part, snowballed out of control and to the point that where they're at now. The next point is that when we did find out about all these violations when the owner attempted to remodel the property. He was told that he had to seek an order lifting the demolition order, and when he was going through the process of lifting the demolition order, that's when he discovered that there were all of these other violations on the property. At that point, the property still wasn't demolished. They couldn't get approval of the plans to remodel because of all these fines that were pending. So they eventually decided to demolish the property themselves. But when they applied for a demolition permit, I guess it triggered something with the city, and then the city demolished it first, leading to a fine or costs that were in excess of what the owners had lined up for the demolition of the property. But they paid that. They paid, I believe it was over $28,000 to the city for demolishing the structure. Now they have a local owner in addition to the Martinique owner, so this will never happen again. They've got a structure in place where they're going to become aware of any kind of violations, if there are any, and then we'll be able to cure them very, very promptly. The last point I'd like to make, and I think it's important, is that the reason why we're seeking to address and mitigate these fines is to make it economically feasible and practical to improve the property. There's nothing there now, it's just a lot. The owners of the property have plans already to build a beautiful multi-family structure on the lot. They have all of the pieces in place, they're ready to go to create additional housing for the city. And just, I think maybe it's worth mentioning that today we heard a lot of discussion about how the city desperately needs additional housing. So this will provide additional housing. My clients do want to pay to rectify some of the issues, but if the structure had been demolished in accordance with the demolition order, case number 1 wouldn't exist at all. So if we were to, just looking at cases number 2 and 3, those cases total about $650,000 of fines, and we are proposing a little bit less than 10% of those two, based on the fact that one of them was for graffiti. That there's a provision in the Code of Ordinances that does say that the city will remove the graffiti if it's not removed within 5 days. But it's really that one case that deals with that wouldn't have existed if the structure had been demolished, that I think is really sort of the bone of contention and sort of the meat of the dispute. If we can get rid of that one, the mitigation on the other ones, I think a reasonable mitigation would make it economically feasible again to develop this property and for the benefit of the city and its residents. Thank you.
Attorney Dooley?
Right. So I didn't comment before because I didn't know if he would go down that road. From our office's perspective, what you guys determine as a body to mitigate to is up to you. In terms of an argument that this is the city's fault, for us is incredulous. It's as if saying, well, if your client wasn't living in Martinique and they were living in the United States taking care of their property, also these things would have happened. But we are under no duty to do that. It's not the city that enters an order. It's an unsafe structure panel. And there is no law, statute that requires us to move forward on a demolition. I don't think, or case law even. So I do not find, and I would ask this court not to find, this body to find that there's any credibility with that argument. Now, as to the other things that he's saying, I think those are reasonable and viable arguments to make to the body in terms of why they're looking for the mitigation that they're looking for with the cases. But those 3 cases do stand. They are valid. The one case he's talking about is the 2020 case. And so the unsafe structure case was from 2019. They did pay, it was over $20,000, I believe, for the demolition that the city did perform. So they already have outlaid that money. And then on top of that, they have, I believe, their offer of almost $30,000 again to close out the 3. Correct?
Yeah, and I would just maybe...
So, that'll be it.
Yeah, and I would just clarify that if I could, that I'm not today suggesting that it's the city's fault. I'm just pointing out that as a practical matter, if the structure had been demolished in accordance with the demolition order, that first case for almost $500,000 in fines wouldn't exist. That's all.
Thank you. This mitigation case falls within my district, and I have a couple of issues with it. One, work without permit doing work without a permit suggests that the owner is somewhat aware of what's going on with the property. I do not condone work without a permit. And then the other, I would tend to be more lenient with the graffiti abatement, except for absentee owners, because that just creates an eyesore in my district. And I want to discourage anyone that thinks they can have a property in District 5 and you don't take care of it, you just leave it. It becomes such an eyesore that there's a demolition order on the property because it's now become unsafe. My district is one of the poorest districts in the city of Miami, and I would suggest that this kind of non-compliance would not happen so vagrantly in other districts. This ran for 1,694 days in one case, 981 days in another case, 995 days in the third case. But this is not just an independent property. This is a property that is surrounded by neighbors, businesses. And because of your client's neglect and not being a present owner, my community had to deal with this for a very long time, years. So I'm not inclined to accept less than 3% of the violations here, and not even for the graffiti, because I do feel for businesses that are tagged repeatedly, for business owners that are present, but not for absentee owners. So I cannot accept less than 3% for this. And I don't want people to think that you can just come before us and we're going to say, okay, you can pay 1% of the fines that have amassed for years, because that's not fair to my neighbors. It's not fair to my neighbors to have to live amongst this. I would give you the opportunity to defer this, to further work out a settlement so that I don't have to say one, if that's agreeable to you.
It is, yes.
Well, in my briefing, it's less than 3%. No, not mine. It's not 3%. I don't settle any of my cases for less than 3%. Unless there are mitigating circumstances, none of which I have here. He has agreed to defer the item, so we're going to defer RE3 to give you an opportunity to further speak with staff to come up with a better offer without me having to make it right here on the spot.
And I appreciate that.
Thank you so
Thank you.
much. May I have a motion to defer RE3? I have a motion.
Motion.
I have a second. All in favor?
Aye.
Motion carries unanimously.
And Chair, will that be to November 21st or December 12th?
December 12th.
Understood.
RE4.
Good afternoon, Madam Chairwoman. RE4 is a mitigation of a property located at 6318 Northwest 2nd Avenue. The respondent is MIA Housing 2 LLC. The case CE 2018-02-2165 is for construction work without permits, to wit, a fence, rather large, oversized, white wooden fence. NOV issued on October 18, 2018, adjudicated on February 7, 2019, complied on August 24, 2023. Is there someone?
Over here.
Is there a counsel for RE4? I can finish my presentation, but if there's no one, no respondent.
Going once, going twice.
I would ask for the full amount of the fines.
$399,750.
I have a motion. All in favor?
Aye.
Thank you, Madam Chairwoman.
Motion carries unanimously.
As amended?
As amended. We now have RE 6, 7, 8, 9, 10, 11,
What about-
12.
Yeah.
I missed 5?
Yeah, you didn't.
I'm
that's
sorry.
fine.
Okay, we now have RE 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Are there any of these items that would like to be pulled for discussion? Mr. City Clerk?
And just for the record, RA 8 will need to be amended pursuant to substitution memo dated October 22nd, 2024. And RA 13 will need to be amended. The 6 whereas clause needs to be amended to reflect 2025. It currently states 2024.
And Mr. City Clerk, do you show me as a sponsor for RE 12?
Yes, that was stated earlier this morning.
Okay. I think we all should sponsor that.
You're in favor of RE7, Commissioner Pardo?
Yes.
Okay, put me as sponsor on that too.
I'm sorry, Commissioner Coyle, sponsor for
RE7.
RE7?
We're not discussing RE12. We're not doing RE12 now, right?
If you would like to discuss it, yes. If you'd like to pull it for discussion, otherwise we'll just vote on it.
Yeah, I'd like to pull it for discussion.
Okay, we'll pull that one for discussion. Todd,
RE12?
RE12. Todd, I'd also like to be a sponsor for RE7.
Understood.
Okay, I have RE12 pulled for discussion. Are there any other items that you would like to pull for discussion? Any other items to be pulled for discussion other than RE12?
Oh, hold on. How far in the REs did we get to?
We finished RE5. We finished RE4. We have RE5 through RE14 in play,
Okay.
with RE12 being pulled for discussion.
RE14,
RE14 is in play.
big play.
It's in play.
That's for your whole 17 years of the extension?
Yes,
Why so little?
that's what we were given. That's what we were advised.
I think you were advised wrong. It should be more than that, I believe, and maybe you need to wait just a little more to bring the interest rates down, and you could bring it up by another 30, 40, 50 million. That's my thought.
Mr. CFO?
Larry Spring, Chief Financial Officer. Commissioner Corey, this transaction is being worked on by Sergio Masvidal from PFM. City's not worked on it, but my understanding is the capacity calculations were done based on where their TIF is right now, subtracting any first place security or first place obligations that they have. And remember, they do have, some TIF agreements and things that exist in place prior to their total amount.
What interest rates are they going at?
I have not seen any of their the number runs.
I just want you to get the most.
I as well. Bond counsel
But
seems to feel like
we need-
based on all of the things, I don't know if any of the CRA persons are still in the building.
Well, let me put this on the record. The reason why you need to, from a timing standpoint, we need to get this bond resolution approved today. You don't have another meeting, and this item has to go to the county for approval.
I see.
So
Okay, well, but you don't have to put it out
we don't have to put it out yet, no.
until we see how the market gets,
Yes.
right?
Matter of fact, the estimate is that this debt won't be issued until December. There is one issue that I know that is being addressed that does have a timeliness issue, which is the Tri-Rail, the funding of the Tri-Rail grant, which is about $17.5 million that we've been working with Tri-Rail on. But it definitely.
Why are we going to limit it to 150 million if the interest rates gets better for next year, which it's going to, and this will go up more?
Well, what I would suggest or recommend right now is that we approve this authorization at this up to amount and allow for us to continue through the process, because it does have to go to the county and go through all their committees and everything, and then maybe bring an amendment to the authorization based on a future calculation. That if there is some interest rate impact.
Okay, I'm just wondering, to save all that, if you couldn't put a clause in there that it could go up to a certain additional amount if the interest rates.
You could authorize it for a larger amount right now, actually.
Yeah.
Well, Bobby.
As amended. We could do an as amended.
Yeah.
Up to.
Yeah, so the CRA already approved it at 150 million. So to approve something above that, would still have to go back to the CRA. So
well, we're here.
Yeah, but doing that's just mechanics, right? I mean, they can always increase the amount and then just take it back to the.
You could reconvene your CRA meeting that you had earlier.
Yeah, and reconsider the item.
Yeah, and reconsider the item.
Okay.
But it is important from a timing standpoint that.
Yeah, that I understand.
Yeah.
And you need to have the time for bond counsels to prepare everything.
Well, more than that is to go through the county's process. This is going to go here to the county.
Right. Okay. We're going to hold off on RE14. If there's no other item that my colleagues would like to pull for discussion, may I have a motion for RE6, 7, 8, 9, 10, 11, and 13?
Madam Chair, you forgot 5 again.
Again?
Yes.
Okay.
That's 5
RE5, 6, 7, 8, 9, 10, 11, 13. I have a motion?
Second.
And a second. All in favor?
Aye.
Motion carries as amended with RE8 and RE13. Now, for discussion, RE12. Commissioner Gabella, I believe you pulled.
No, you guys go ahead. I'm holding my thoughts to the end.
I don't think anybody else.
It is very clear what we're trying to do.
Okay.
It is quite clear that we are asking that local be modified and be modified. I have heard people saying that we can opt out, and according to our attorneys and everybody that knows about it, it's not possible here because to start with, we don't have excess housing units here. That will be one of the requirements, and I have also heard that we should sue them. And Mr. City Attorney, could you go and be more clear on it?
Yeah, I'll address first the opt-out.
Yes.
That's sort of a misnomer in that there is a provision under the statute that says a taxing authority must, beginning with the 2025 tax roll, the taxing authority may elect upon adoption of an ordinance or resolution approved by a 2/3 vote of the governing body not to exempt property under subparagraph D1A located in a county specified pursuant to subparagraph 2. Basically, what we're talking about is they call it the missing middle. The opt-out provision that became effective in July 2024 is related to the missing middle property tax exemption that's part of the act. The missing middle property tax exemption is an ad valorem tax exemption for the affordable units in developments that contain over 70 affordable units for households up to 120% AMI. Units that serve households from 80 to 120 AMI receive a 75% tax exemption, and units that serve households below 80% receive a 100% property tax exemption. Taxing authorities may opt out of this tax exemption if located in a county in which the number of affordable and available units for households at or below 120 AMI is greater than the number of households at that income level, as determined by the most recent Schimberg Center for Housing Studies annual report. That's pursuant to 196.1978.301. So the opt-out provision that you may see in the paper is where a taxing authority like Orange County, Florida, says, we're not going to give that tax exemption. But there is no opt-out of Live Local, if only there were, right? But there is not. And as far as litigation, right now I'm aware of at least one case. Doral had litigation. I believe they resolved it with the developer. Bal Harbor currently is being sued by a developer because Bal Harbor is not following the Live Local provisions. So all of the municipalities in the state of Florida are watching that case to see what happens. Pasco County in 2023 threatened to sue, and then the state threatened to take away discretionary funding, and they withdrew their saber rattling. So we will continue to monitor it. If there's an opportunity for us to challenge it, we will. But right now, this resolution urging the governor and the legislature to make modifications to it is a very good first start, in our opinion.
Madam Chair?
Yes, Commissioner Reyes.
Yes, and I want to make clear that this is does not only address the Sears development, it addresses about 21 or 22 potential development that they could try to use Live Local.
That's why I am a sponsor of this item as well. Live Local could be very detrimental to my community.
Absolutely.
Particularly on the Upper East Side. My neighbors feel very passionate about the footprint of our neighborhood. I have been working with State Representative Vicky Lopez, who tried last year to get this legislation amended and is still trying to work with it. It is, and this is why politics are local, right? Because we know our neighborhoods best, and we know it will also be a disaster in RTZ zones.
Yes.
So
where we wouldn't have a say. So I completely support this legislation. Commissioner Gabella, I believe you wanted to say something.
What exactly are we amending, Wison? What are we asking?
We're not amending anything.
What are we asking the legislators in Tallahassee to actually amend?
We're asking.
I'm sorry, I haven't been keeping up with.
No problem. So this resolution will ask the Florida legislature to prohibit developments under the Act to be located adjacent to property zoned single-family residential on one or more sides or adjacent to a neighborhood conservation district. And I just
That's
wanted,
it? Those are the only two things? Okay, I'm ready.
I just wanted to comment real quick to address what the
No,
chairwoman said, which is during public comment, a lot of people challenged you all to take action against Live Local, but they don't realize that the word preemption means that the state of Florida has taken away your power. And so really, the state of Florida is in control of this issue. These are not unintended consequences. This is what the Florida legislature intended, is to take away your authority over these rezonings.
If I may add, Madam Chair, about 2 or 3 years old when this started, I went to Tallahassee. I had my conversations and also arguments with the proponents and how would that be detrimental at the time, detrimental to the city of Miami and a lot of cities, because there are other aspects of Live Local that we are not discussing here. And they, at the time, they were allowing that in workforce, it could be up to 140. I placed a strong argument about it because that is not 140 of AMI. It is not it's a misnomer for workforce because you could be making over $100,000 and still qualify for this. So I think that we had a little bit of positive result, but we have to keep on working on it, and we even met with the League of Cities, and we are trying to get them on board. Okay, and I'm moving this.
I have a motion.
Second.
Second. All in favor?
Aye.
Motion carries unanimously. Let's go to Mr. City Attorney. Would you please read the titles into the record for our second reading ordinances?
Yes, Madam Chair. Second reading 1, an ordinance of the Miami City Commission repealing Chapter 11.5 of the Code of the City of Miami, Florida, as amended, titled Civilian Complaint Investigation and Review, in its entirety, further amending Chapter 18, Article 3, titled Finance, City of Miami Procurement Ordinance, specifically by amending Section 18-72, titled Application and Exclusions, and Section 18-74, titled Cone of Silence, to remove preferences thereto, containing a severability clause and providing for an immediate effective date. SR2, an ordinance of the Miami City Commission amending Chapter 23, Article 1, Section 23-6 of the Code of the City of Miami, Florida, as amended, titled Historic Preservation Transfer of Development Rights and Density for Historic Resources, provision for determination of eligibility process, and special provisions for resources within the Miami Modern, MIMO, Biscayne Boulevard Historic District, prohibiting certain uses and establishing a 35-foot height limit to allow height increase for projects providing a public benefit by a public agency to the Miami Modern, MIMO, Biscayne Boulevard Historic District community, containing a severability clause and providing for an effective date. That's it for the second reading.
Gentlemen, are there any items in the SR's second reading items that you would like to pull for discussion?
Briefly, SR2.
Okay. Anything else? May I have a motion for SR1?
Motion.
I have a motion and a second. All in favor?
Aye.
Aye.
Motion carries. Commissioner Commissioner Pardo?
On SR2, I just simply wanted to, for the record, state that it's very restrictive in order to be able to do this, and that has to be a public benefit by a public agency. And I think a lot of people think this is just an increase in general and it will impact everything. It's only in the MIMO district, and it's only regarding that
Correct.
specific situation, which I think can only apply to maybe one or two.
Correct. Well, further, this is not about any project as yet. This is only giving us legislation that can entertain a public-private partnership with specific criteria. Correct, Director Snow?
That is correct. And we also went a step further to specify city, specific to the city agency.
Correct.
It's very narrow.
So this is only the legislation that authorizes a public-private partnership with a city agency. That's it. Next step would be to identify the project, the specifics of the project. This just allows us to entertain a project.
And this vote allows it to go to the HEB board.
Yes. Okay. So may I have a motion?
Motion.
I have a motion and a second. All in favor?
Aye.
Motion carries unanimously. Mr. City Attorney, would you read FR2, the title, into the record for consideration?
Yes, Madam Chair. An ordinance, FR2, an ordinance of the Miami City Commission amending Chapter 35, Article 7, Section 35-254 of the Code of the City of Miami, Florida, as amended City Code titled Motor Vehicles and Traffic Transportation Trust Fund Payments, more particularly by amending Section 35-254C of the City Code to establish a purchase price of parking spaces payable into the Transportation Trust Fund, containing a severability clause and providing for an immediate effective date.
Do I have a motion? I have a motion and a second.
Second.
Any discussion? Motion and a second. All in favor?
Aye.
Motion carries unanimously. discussion item 1. No, we finished the FRs. Discussion item. There's a discussion item.
Oh, that's you. Pardon?
Okay, I'd like to come back to my mitigation item. I thought by saying that I'd like the total amount of the fines that somebody would step forward. Where are we?
So, good afternoon. I apologize. RE4, which you voted on, I'd ask if that could be reconsidered. I looked for counsel. This attorney, I won't even say his name, but he's here all the time. I called him up, and there were some emails that went back and forth. They're working on their affordable housing covenant, and so they were going to come back when things were completed. They were looking for the November or December date. So it was my error in not getting that to them earlier, and I do apologize.
May I have a motion for reconsideration?
Make the motion.
Second.
I have a motion and a second for reconsideration. All in favor?
Aye.
Aye.
Now, may I have a motion to defer RE4 to the December 12th?
RE what?
RE4, mitigation, to the December meeting. I have a motion?
Second.
All in favor?
Aye.
Motion carries unanimously. Thank you. It worked. Discussion item. You said wait for it. Okay. Mr. City Attorney, would you please read the planning and zoning titles into the record so we may consider these items?
Yes, Madam Chair, and I appreciate your patience. PZ1, an ordinance of the Miami City Commission with attachments, amending ordinance number 10544 as amended, the future land use map of the Miami Comprehensive Neighborhood Plan, pursuant to small-scale amendment procedures subject to Section 163.3187 Florida statutes by changing the future land use designation from single-family residential and medium-density multifamily residential to medium-density restricted commercial and restricted commercial for the property generally located at 160 Northeast 50 Terrace, 162 Northeast 50 Terrace, 170 Northeast 50 Terrace, 184 Northeast 50 Terrace, 183 Northeast 50 Street, 177 Northeast 50 Street, and 169 Northeast 50 Street, Miami, Florida. Collectively, the property more particularly described in Composite Exhibit A, attached and incorporated, making findings containing a severability clause and providing for an effective date. PZ2, an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended, Miami 21 Code, by changing the zoning classification from T4L, General Urban Zone Limited, to T50, Urban Center Zone Open, for the properties generally located at 5010 and 5040 Northeast 2 Avenue, and a portion of 184 Northeast 50 Terrace, Miami, Florida. A change of zoning designation from T4R, General Urban Zone Restricted, to T50, Urban Center Zone Open, for a portion of 184 Northeast 50 Terrace, the west 15.50 feet of Lot 2, Block 7 of the corrected plat of Alta Vista, Miami, Florida. A change of zoning designation from T4R General Urban Zone Restricted to T5L Urban Center Zone Limited for the properties generally located at 162, 170, and a portion of 184 Northeast 50 Terrace, Lot 3, Block 7 of the corrected plat of Alta Vista, Miami, Florida. A change of zoning designation from T4R General Urban Zone Restricted to T4L General Urban Zone Limited for the properties generally located at 169, 177, and 183 Northeast 50th Street, Miami, Florida, and a change of zoning designation from T3L Suburban Transit Zone Limited to T4L General Urban Zone Limited for the property generally located at 160 Northeast 50 Terrace, Miami, Florida, collectively property as particularly described in Exhibit A, attached and incorporated, making findings and providing for an effective date. PZ3. An ordinance of the Miami City Commission with attachments amending ordinance number 10544 as amended, the future land use map of the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to 163.3187 Florida statutes by changing the future land use designation from medium-density restricted commercial, western portion, and public parks and recreation to restricted commercial of the acreage described herein of real property located at 8032 Northeast 2 Avenue, Miami, Florida, as more particularly described in the attached and incorporated Exhibit A, making findings, containing a severability clause, and providing for an effective date. PZ4, an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended by changing the zoning classification from CS Civic Space Zone to T680 Urban Core Transect Zone Open and T50 Urban Center Transect Zone Open to T680 Urban Core Transect Zone Open for the western portion of the property generally located at 8032 Northeast 2 Avenue, Miami, Florida, is more particularly described in the attached and incorporated Exhibit A, making findings, containing a severability clause, and providing for an effective date. PZ5, an ordinance of the Miami City Commission with attachments pursuant to Articles 3 and 7 of Ordinance Number 13114, the zoning ordinance of the City of Miami, Florida, as amended, Miami 21 Code, amending the zoning atlas of the Miami 21 Code by changing the zoning classification from T612O to T624AO for the properties located at 1411 Northwest North River Drive, 1421 Northwest North River Drive, 1441 Northwest North River Drive, 1451 Northwest North River Drive, 1465 Northwest North River Drive, 1481 Northwest North River Drive, 1440 Northwest 13 Terrace, 1430 Northwest 13 Terrace, and 1424 Northwest 13 Terrace, Miami, Florida, as more particularly described in Exhibit C attached and incorporated. Further amending Appendix G of the Miami 21 Code titled River Landing Special Area Plan, RLSAP, as more particularly described in the amended regulating plan attached and incorporated as Exhibit A, and the amended concept book attached and incorporated as Exhibit B, specifically by A, adding to the RLSAP approximately 88,039 square feet, 2.02 acres of lot area split among 9 additional parcels for a total combined area of 442,570 square feet, 10.16 acres, with the attached properties more particularly described in Exhibit C, attached and incorporated. B, proposing new development to add 475 dwelling units and an additional large green space to the RLSAP. C, amending the regulating plan and the concept book to include the development of the additional area and to also include revisions for the consistency with the Miami 21 Code. And D, making findings, containing a severability clause, and providing for an effective date. PZ6, an ordinance of the Miami City Commission with attachments approving a development agreement pursuant to Chapter 163 Florida statutes and authorizing the city manager to negotiate and execute said development agreement in a form acceptable to the city attorney, a draft of which is attached and incorporated as Exhibit B between No Truce Holdings, LLC, applicant, and the City of Miami, Florida, governing the properties generally located at 1411 Northwest North River Drive, 1421 Northwest North River Drive, 1441 Northwest North River Drive, 1451 Northwest North River Drive, 1465 Northwest North River Drive, 1481 Northwest North River Drive, 1440 Northwest 13th Terrace, 1430 Northwest 13th Terrace, and 1424 Northwest 13th Terrace, as more particularly described in Exhibit A, attached and incorporated, making findings, containing a severability clause, and providing for an effective date. PZ7, an ordinance of the Miami City Commission amending ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended by amending Article 3, titled General to Zones, to expand the Affordable Housing Transfer of Development Density Program to include opportunity zones and to provide other minor clarifications containing a severability clause and providing for an effective date. PZ8, an ordinance of the Miami City Commission amending ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended by amending Article 1, titled Definitions, to introduce a definition for game courts by amending Article 5, titled Specific to Zones, to allow additional fence and wall height necessary to enclose outdoor leisure activities, and by amending Article 6, titled Supplemental Regulations, to amend the maximum height for walls and fences related to infrastructure and utilities uses, making findings, containing a severability clause, and providing for an immediate effective date. PZ9, PZ9 is a resolution. PZ10, ordinance. An ordinance of the Miami City Commission amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended by changing the zoning classification from CS Civic Space Transect Zone to T612O Urban Core Transect Zone Open for the southwestern portion of the property generally located at 980 MacArthur Causeway, Miami, Florida, more particularly described in Exhibit A, attached and incorporated, making findings containing a severability clause and providing for an effective date. PZ 11, an ordinance of the Miami City Commission with attachments amending ordinance number 10544 as amended the future land use map of the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to Section 163.3187 Florida statutes by changing the future land use designation from medium-density multifamily residential to restricted commercial for the properties generally located at 625, 645, 675, 685, 650, 640, 630, and 626 Northeast 64 Terrace, and 635, 645, 655, 669, and 685 Northeast 64th Street, and from restricted commercial and medium-density multifamily residential to restricted commercial for the properties located at 610 Northeast 64 Terrace and 629 Northeast 64th Street, Miami, Florida, as more particularly described in Exhibit A, attached and incorporated, making findings and providing for an effective date. PZ 12, an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended, Miami 21 Code, by changing the zoning classification from T5R, Urban Center Transect Zone Restricted, to T68L, Urban Core Transect Zone Limited for the properties generally located at 625, 645, 675, 685, 650, 640, 630, and 626 Northeast 64 Terrace, and 635, 645, 655, 669, and 685 Northeast 64th Street, and from T5R, Urban Center Transect Zone Restricted, and T680, Urban Core Transect Zone Open, to T68L, Urban Core Transect Zone Limited, and T680, Urban Core Transect Zone Open for the property located at 610 Northeast 64 Terrace, and from T5R, Urban Center Transect Zone Restricted, and T680, Urban Core Transect Zone Open, to T68L, Urban Core Transect Zone Limited for the property generally located at 629 Northeast 64th Street, Miami, Florida, more particularly described in Exhibit A, attached and incorporated, further recommending to the City Commission acceptance of the voluntarily proffered covenant, attached and incorporated as Exhibit B, making findings containing a severability clause and providing for an effective date. PZ 13, an ordinance of the Miami City Commission with attachments amending ordinance number 10544 as amended the future land use map of the Miami Comprehensive Neighborhood Plan pursuant to small-scale amendment procedures subject to Section 163.3187 Florida statutes by changing the future land use designation from duplex residential to medium-density restricted commercial of the acreage described herein of real property at 55 Northwest 23 Avenue, 2250 Northwest Flagler Terrace, and 2260 Northwest Flagler Terrace, Miami, Florida, as more particularly described in the attached and incorporated Exhibit A, making findings containing a severability clause and providing for an effective date. PZ 14, an ordinance of the Miami City Commission with attachments amending the zoning atlas of ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended, Miami 21 Code, by changing the zoning classification from T4R, General Urban Transect Zone Restricted, to T5L, Urban Center Zone Limited for the property generally located at 55 Northwest 23 Avenue, 2250 Northwest Flagler Terrace, and 2260 Northwest Flagler Terrace, Miami, Florida, as more particularly described in the attached and incorporated Exhibit A, making findings containing a severability clause and providing for an effective date. PZ 15, an ordinance of the Miami City Commission amending ordinance number 13114, the zoning ordinance of the City of Miami, Florida, as amended, Miami 21 Code, more specifically by amending Article 1, Section 1.2, titled Definitions, Definition of Terms, and Article 7, titled Procedures and Nonconformities, to provide for a by-right administrative site plan review, ASPR, process and a simplified building permit review process for approved ASPR, exception, variance, warrant, and waiver applications, providing for tolling of zoning approvals during pendency of certain litigation, replacing the 2-year time limitation and optional 1-year extension for obtaining building permit or certificate of use for an exception, variance, warrant, waiver, or ASPR with a 3-year time limitation with no administrative extensions, revising phased project requirements as to approval by planning director and to reduce property size limitations, clarifying previously adopted floor plate length and area waiver prohibitions, providing for applicability to prior applications and approvals, making findings and technical changes containing a severability clause and providing for an immediate effective date. And that's it for your PZ items.
Thank you. I'm going to ask my colleagues if there are any items that they would like to pull for discussion.
Madam Chair, I have to make a genuine disclosure
Okay.
for the items 1 and 2 and 13 and 14. And before we vote on item 13 and 14, I would like to get a commitment from the attorneys.
Okay.
Good afternoon, Madam Chair, Commissioners. Carlos Diaz with office at 333 Southeast 2nd Avenue, here on behalf of the applicant. Yes, we would like to we'll make a proffer to bring a covenant back for a second reading for this item.
Which item is it?
PZ 13 and 14.
13 and 14.
The covenant order will be for 14, right, the rezoning, but we're committing to bringing that back, and we'll have all the details there. We'll work it out with staff and ready for commission on second reading.
Okay? You remember what I told you?
Yes.
Okay.
Clear.
Thank you. I have no more any other.
Are there any items, Commissioner Pardo?
I have a Jennings disclosure on PZ 11.
And 12. PZ 11
And 12.
And 12. Okay.
Are you going to do all the PZs together? Because I will be voting no on 13 and 14.
Okay, so I'll pull out 13 and 14. I'll just do those separately. I have a Jennings disclosure for PZ 9. So are there any other items? Okay. May I have a motion to pass PZ 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 15?
Motion.
I have a motion and a second. All in favor?
Aye.
Aye.
Motion carries unanimously. May I have a motion for PZ 13 and 14?
Move it.
I have a
Second.
motion. I have a second. All in favor?
No.
Aye.
Aye. Passes.
I am
4
against.
Sorry.
4-1.
Madam Chair.
Yes.
Okay.
PZ 6, the development agreement, there has been updates that have been made to that. So those revisions will be
As amended?
as amended.
PZ.
Whoa. So we've already taken the vote on PZ 13 and 14.
Yeah, it's
So we're
4-1.
going to reconsider then PZ 6.
May I have a motion for reconsideration of PZ 6?
Motion.
I have a motion. Second. All in favor?
Aye.
Motion carries. May I have a motion to pass PZ 6 as amended? I have a
Second.
motion and a second. All in favor?
Aye.
Aye.
Motion carries unanimously. We have future legislation just for consideration. Give everybody notice. And that, I'm sorry, we have to go back to RE 14. And DI 1. Okay. Mr. CFO. It has been brought to my attention that we cannot put language in up to, we will not be able to get more than $150 million for the bonding of the Southeast Overtown Park West CRA.
Yes, while we were at break, I had an opportunity to speak to the city's FA who worked on this deal or has been putting the deal together. Based on his calculations, the $150 million is the capacity that they're at based on the available pledgeable revenues, applying the 1.5 times coverage ratio.
Well, it would have to be 2 times,
Two-
not 1.5 times. This is not going to a referendum.
That's no. 2 times applies you have it in reverse. 2 times would apply for a GOB bond, 154 CRA.
Now, what is the interest rate that he's going at?
They ran this as of September 25th, and the all-in total all-in cost is 5.906.
Okay, well, I would say that before he goes out, it just be brought up to this commission's attention again, because I do believe that for next year, the interest rates will be better than what is there now, and we should get an uptick in this.
We will certainly ensure that you do so.
Thank you. May I have a motion for RE 14?
Move.
I have a motion
Second.
and a second. All in favor?
Aye.
Motion carries unanimously. We are DI 1.
Is that the last thing on the agenda?
I believe DI1 is the
It will
last.
be the last thing.
Mr. Manager, could you bring all your key people that have to do with code over here, the director, and if you have your top assistant city manager, if he's here today, for building and zoning? Thank you. While the manager's getting them from the back, if I could go with a very brief presentation. You see up here the now famous outdoor gym equipment that's at Maurice Ferre Park. That was passed with 80% votes of the city residents, including the majority, big majority of the votes across the street from the residents that we were told by Mr. Pardo that we're all against it. You go to the next picture. And you see how small of an area it is in Maurice Ferre Park. A 20-acre park. Now, as you can see, this is a plain Jane outdoor exercise equipment that we have in most of our parks. You don't have to go far. You could go right here, a couple of blocks to your left in Myers Park. You got some there. You go to Kennedy Park here in the Grove. You got more in all of our districts. We have outdoor exercise gym equipment. In fact, in around 40 of our parks, we do. We go to the next one. This, however, we don't have in all of our districts. It's only in one district. This has been there for a year or more. This is outrageous that we had to do last year's New Year's Eve event, that we had approximately 150,000 people that came, another 300,000 or more that saw it in TV in South Florida, and hundreds of thousands more that saw it throughout the world. Number one country outside of the U.S. was Mexico. Number two was Spain. And if you see it here closely, you see that this is not just so-called graffiti. This is vandalism, the way you see it here. This is to purposely have made this building look like crap, so that we, City of Miami government, the residents of Miami, would be embarrassed. And it was done by owners that inherit this building because, as I understand it, they were mad that code did something to them or another because they had committed some violations. and they wanted to show this to us. Look at that. I mean, this is every floor. This is not something that you could have done overnight, hidden, and get away with it. This was done during numerous days, and they let him do it. They let him get away with that. Go to the next picture, please. You see how it looks from another angle? You showed me one city in the world that would allow this. You show me one area of the city of Miami, or for that matter, any city in our county or unincorporated areas that would allow this. Next one, please. You see how this is all abandoned, where it is extremely dangerous. They're letting people now go in there, and you see them downtown, homeless coming in and out of there. This is from street level all the way to the top of the building as you've seen it. Go to the next one, please. You see what they've done to it on the other side of downtown and how it looks at the street level. Next one, please. And this view is going to be, well, let me explain. This is the fountain that hasn't been working, and we took over Bayfront Park with a fountain that had been like that for decades. God willing, the fountain will be working before the end of the year. God willing. Right in front of that pink area there that you see there now, where the vehicles are, is where the stage goes for New Year's. The New Year's Eve that the city of Miami puts out, it's the second biggest in America. The second biggest in all of America. It's the number one in the whole world for the amount of musicians, singers that come in. We have so many that we start at 6 p.m. and we go live on TV at 6 p.m. all the way till at least 1 in the morning. It's also the largest Hispanic New Year's Eve event anywhere in the world, Latin America. This is the view that people are going to have. Tens of thousands of people that are going to be gathered there are going to have of our downtown, including thousands of visitors that come during that time of the year. When we have the Orange Bowl Classic, the championships that are played, right at the Intercontinental, we have one of the teams to stay. Can you go forward more? This is the same view that you see in a close-up that they're going to see. This is another aspect that we have in front of this building and right in Biscayne Boulevard, the adjacent area of homeless. You see that? Go to the next, please. Another one. Go ahead. Another one. And what do you want to go in farther in? Because then I would have to be showing you dozens upon dozens of homeless all gathered. This is just right in the either Biscayne Boulevard or just a little in from Biscayne Boulevard. I cannot, for the life of me, understand how the only thing that's been important for my colleague, Commissioner Pardo, has been to get rid of the outdoor exercise gym, but he hasn't put that same effort, nowhere near it, to make sure that this graffiti is taken out of that building in one form or another. I submit to you that I think the residents of Miami, as they voted, would have preferred for him to have put all his efforts, the lawsuit that he filed, the PAC that he opened, and money that he raised to try to get the gym equipment out, in trying to get this graffiti out of this building. But my colleague hasn't cared about that. He's cared about the gym equipment, not taking care of this. Mr. Manager, we were recently at a DDA meeting that I thank Commissioner Reyes for putting together. And he's a witness, just like Commissioner Pardo is, since he talks about the residents. Well, this is not the 5 or 6 residents that he's always talking about. This were dozens of residents that were complaining about this building, about this, wanting the city to do something about it. They were told at that meeting that, oh, it's going to be taken care of right away. Right away is here. It's been a year or more. This has got to be taken care of before our New Year's Eve celebration this year. And this is why I am going to make a motion that if none other of the permits that these people supposedly are working on or have made mistakes on or whatever the case is, to take that building down in a safe way, don't happen by the 29th of next month for this administration to do whatever it takes and it has to do to paint over all that graffiti, to paint over all that stuff that was painted in there, so that we don't have to have our residents be looking at a building that looks like this and wonder what kind of a city do we have here. So my motion is to instruct the administration in a little over 30 days, by November 29th, if they don't paint over that building, or if they don't get whatever permits in the proper and safe fashion they have to get to tear that building down and take it down, that the administration is instructed by this commission to do whatever it has to. Can you leave this one out here, please? To paint over that whole building. And we build them for it and lean the place until we get paid by them.
I'll second it.
Thank you.
I have a motion and a second. All in favor?
Aye.
Motion carries unanimously. This shall conclude the commission meeting for October 24th, 2024. Thank you all. Thank you for always coming. Meeting adjourned.